What do you think would be the impact of this judgment on the movement for the abolition of death penalty?
Death penalty was widely prevalent during the period of monarchy in India. It was actually a symbol of monarchism that the king had the sovereign right on the life of every subject. After that came the East India Company, which hanged many small kings or chieftains such as Veeravandiya Kattavammu and the Marudu brothers and others. In 1857 we had the first war of independence. In 1858 it was the Victoria Declaration by which the British came to rule India directly. And they needed a penal law taking into consideration the experience of the first war of independence, which they called the Sepoy Mutiny. And it was Macaulay who drafted the Indian Penal Code in 1860. Maybe it's not a coincidence that it was he who was the author of the Indian education system also. From 1860 onwards, the IPC or the Indian Penal Code is alive and kicking to this day, the same Indian Penal Code, under which death penalty is a sanctioned sentence for certain crimes, especially murder. There have been very few amendments or corrections to this penal code, but through amendments to the Criminal Procedure Code and other penal codes, there have been a restriction of the range and area of operation of death penalty. And now it has been restricted to the rarest of rare cases. First, the correction was done when it was announced that the courts cannot normally give death penalty as before. Death penalty was a rule once upon a time and life imprisonment was an exception. Now life imprisonment was made the rule and death penalty an exception. Whenever one is awarded life imprisonment instead of death penalty, the judge has to record special reasons or mention the extenuating or mitigating circumstances that leads to this leniency in sentencing. Then there was the 1973 Code of Criminal Procedure, and every judgment was separated into two parts, first the conviction and then the sentence. Once the conviction is pronounced, then the convict or his counsel would have a chance to argue on the severity of the sentence. Then in 1978 there was the amendment 433A to the CRPC, which made it mandatory for a prisoner who has been sentenced to life instead of death to serve 14 years of actual imprisonment before being considered for release. Then in 1980 there was the Bachchan Singh case, which challenged the constitutional validity of death penalty itself. The argument was that death penalty violates the right to life and liberty guaranteed by Article 21 of the Constitution, because it is arbitrary, it is not just, it is unfair. It is based on the subjective fancies, subjective whims and fancies of the judge himself, etc. And it was Justice Bhagavati who ruled that death penalty was unconstitutional. But the majority of the judges had given a judgment that death penalty was constitutional, but it cannot be applied as a general rule. They introduced a new rule that only in rarest of rare cases can death penalty be given. What is a rare case? What is the rarest case? What is the rarest of rare? There is no scientific criteria to decide on this matter, the rarity of a case. And that was the argument of Bhagavati. Somehow the rarest of rare cases judgment was upheld, and in various other judgments the Supreme Court has held the death sentence is constitutionally valid. That continues till this day. Even in the recent judgment, when 15 lives were spared, the judgment of January 21st, the Supreme Court has not abolished death penalty. And even in the February 18th case, it has not abolished death penalty. But it has introduced a new terminology, the clemency jurisprudence. And the judges say India can be proud of being ahead in this clemency jurisprudence. And they say it is an evolving jurisprudence. So the matter has not been finally settled. Mercy or clemency is not something that is begged for and given by the powers that be as giving of alms. It is a right of the prisoner, and it is a duty of the government, especially the president and the governor. It is not merely a prerogative of the president, it is a constitutional duty to consider the mercy petition in a fair, just and reasonable way, in a fair, just and reasonable procedure. So Article 21 is not only procedural, it is substantive in its content. That is the argument of the Supreme Court. And this phrase, evolving jurisprudence, means it is not final. When it evolves fully and blossoms into something like a flower of mercy, it means the abolition of death penalty. As Comrade Kannabiran and Balagopal were often saying, it is not the state but the public opinion which is a roadblock to the abolition of death penalty. The general public believes that death penalty is necessary to prevent crime, especially heinous crimes like rape, like killing of children, like murder for gain, etc. And they have to be convinced that death penalty does not prevent these crimes, does not deter any criminal from doing this, and it is not worth the name of a punishment itself, as it destroys a man instead of reforming him and rehabilitating him, etc. There is one more point of view. It was argued by Kannabiran that death penalty is a symbol of monarchism, where the monarch has a power over the question of life or death of a subject who is being convicted. It is the monarch who represents the executive, who represents the legislative, who represents the judiciary. He is the judge, he is the policeman, and he is the lawmaker. So he can do anything, not only in awarding the punishment, but also in deciding upon the form of carrying out the punishment. That is what we saw in Pandian king Nedunchezhiyan asking his gods to go and kill Kovalan just because he had the anklet of the queen herself. He was alleged to have owning the anklet, but later on it was proved false. This was monarchism, and Kannabiran says this has no place in a republic where mercy and pity have no place in the dictionary of human rights. In a civil society, when every citizen is a lawful person who enjoys the right to life and liberty, nobody's life should be left at the mercy of another, even if the second person is the president of the country itself, or at the mercy of the government. And it militates against republicanism. So this mercy jurisprudence, if taken to its logical conclusion, will help abolition of death penalty itself. If you don't need mercy from another and lose your human dignity by begging for your life, if you want to uphold the right to human dignity, this mercy procedure should be taken to a stage where it is abolished. In order to have no mercy procedure, you should not have death penalty itself. So abolition is death penalty is the way to guarantee that no human being is left at the mercy of another or the government for saving his or her life. And this is the logic. And now this judgment, by giving a new content to clemency jurisprudence and saying that it is just evolving, shows the way to a final abolition. There are two ways of doing this. One is, now we have public opinion in our favor, at least in a few parts of the country, in Kashmir, in Punjab, in Tamil Nadu, and to some extent in Andhra too. The Hindu belt or the cow belt, that is still for death penalty. If, as in the United States, every state will have a right to abolish death penalty, we stand a very good chance of abolishing it in our state. The Punjabis can do it in their state. So it is related to the nationality question itself. The self-determination of nations, when it comes to effect, at least internally, at least partially, we can have a change of law. When MGR was a chief minister, a resolution was passed in the assembly that 433A can be annulled. But the president refused his assent to that amendment, and that is why 433A continues till this day. So we can fight for our right to abolish death penalty by having our own penal code, or at least having our own code to the extent that death penalty is not part of it. And this is one way. Or the parliament itself taking a cue from the United Nations and following other countries, including Britain, which is the mother of Indian law, can abolish death penalty through a legislation, through a resolution in parliament itself, and through an amendment to the IPC, which it does not even need a two-third majority, because Constitution does not say anything about this. Actually, the Constitution in its essence, by Article 21, guarantees life and liberty, and it is against death penalty in its essence, as Bhagavati and Krishna and other judges have held. The other way is, the abolition of death penalty is by a practical moratorium on death penalty as suggested by the United Nations. The penalty would be there in law and the courts would be awarding it, but there won't be any execution. This can also be achieved. And by actually filing a fresh petition in the Supreme Court on the basis of the experience, the judicial experience that has been attained since the Bachchan Singh case, we can raise new points. The Supreme Court itself has said that judges have erred in deciding what is the rarest of rare case and what is not. And there have been misjudgments which have even led to false executions, etc. So on this basis, we can also move the Supreme Court and try to judicially abolish death penalty. So these are the ways wide open before us, and we believe it is an achievable goal. And another thing is, whenever a country gets liberated, it does not follow the old laws, especially penal laws of the dominant country. South Africa, for instance, has not only abolished apartheid, but also abolished death penalty, which was part of the apartheid regime. And Tamilam, they have, the translational government of Tamilam has openly declared that there won't be a place for death penalty in the constitution of Tamilam, even though they have every reason to seek revenge upon those who committed the crime of genocide, war crimes, etc., who caused thousands and thousands of girls to go without their husbands, without their fathers, etc. So the peculiar situation here is Britain, which taught us the way of hanging, which hanged Bhagat Singh, Rajaguru, Sukadev, Khudiram Bose, etc. It has abolished death penalty in its own country. But India, which spoke in the Gandhian language to the British masters, to the British Raj, is persisting with the death penalty. And this anomaly has to be corrected. And we hope we can very soon find a day when there is no death penalty in India. It is abolished once and for all, when the hangman's rope has no place in the penal laws.